Good morning.
Sorry.
Good morning, everyone. It's a pleasure for us to be joining you today, and thanks to iTOO for having us on for this session of iTOOsday. Joining me as panelists today is Pernal Gangia, who's a senior associate based in our Durban office, Jenny Govender, who's an associate also based in Durban, Annika de Kock, who's based up in Johannesburg as an associate, Retabile Shabalala, who's also an associate in Joburg, and Lisa Kriegler, who is also based up in the Johannesburg office as an associate. And just to get some of the preliminary sort of issues out of the way, if it hasn't been done already by the conveners at iTOO, if you could please just mute your microphone so that we don't have any interruptions in the course of the presentation. But at the end, I'm sure there'll be an opportunity to ask oral questions. But as we go through the presentation, please feel free to add any questions that you might have as they occur to you in the chat box so that we can then address them at the end. And I'm hoping that I'll be able to move to the next slide. I do apologize for the slight delay in getting started. There was some digital highway issues, as was alluded to, but there we go. I hope you can all see the next slide. And what we are going to be discussing today as a panel is an area of claims, or an example of claims that we see frequently for our clients, and those are slip and trip claims. We're going to give you a bit of an overview in terms of particularly what to do when an action is instituted in respect of a slip and trip claim, but many of the principles are much the same and would apply as the case may be in a letter of demand or an oral claim on behalf of a third party following a slip and trip incident. And we hope it gives you some food for thought and also some input in terms of things to look out for and approaches to take in dealing with these sorts of claims when they arise. I'm going to briefly just look at what to do and what steps you can take once a summons is received in a slip and trip claim, and then I'll hand over to the other panelists to deal with some of the more granular issues arising as one picks up and has to deal with one of these claims. So first things first, obviously your insured receives a summons and particulars of claim from the sheriff relating to a third-party claim following a slip and trip incident. And there are, of course, the usual initial steps in terms of notifying the insurer and so on to deal with. And it's imperative that that's done as quickly as possible. I'm sure all of you will be aware or have come across it in dealing with these sorts of matters at some point, of the fact that there are court deadlines and timeframes to adhere to once a summons and particulars of claim are received. So as a rule, the ideal situation would be for the insured to send through that summons and particulars of claim as soon as it's received, to ensure that you can then hand it over to the insurer as the case may be, and the matter can progress from there with attorneys being appointed and so on. And it's important to consider the particulars of claim, especially from a legal practitioner's perspective, right at the outset in some detail, to ensure that whatever initial steps are required can be taken timeously in terms of the court rules. And I've set out on the slide there a couple of notices that you could have recourse to in dealing with the slip and trip claim in the High Court, and in fact there are similar rules, although the rules aren't specified there, for the Magistrates Court, depending on the value of the claim that you're dealing with. But the first thing to look at is, does the summons and particulars of claim comply with the legal requirements in terms of the High Court or the Magistrates Court rules, as the case may be. So there are technical requirements such as the third party or the plaintiff specifying that they're an adult male or female, where they reside, and then their employment status. And that's quite important, particularly where you're looking at an early stage and trying to get an idea of what the value of the claim will be, because employment status could obviously have a massive impact on what you're dealing with in terms of the loss of earnings claim as a result of the injuries suffered through the slip and trip incident. So if those things aren't specified, you might want to take either a 30A notice or a 32B notice, which deal with irregular steps and non-compliance with the rules of court. And really, those are largely technical rules, but other issues, particularly in terms of an irregular step, is that it's required that a plaintiff sets out in detail the facts that they rely upon for their claim. And so if you don't have sufficient facts set out in the particulars of claim, it becomes very difficult to assess the merits of the matter. And indeed, in some instances where, for example, there's no incident that was reported at the time that it occurred, no record from the insured side as to what happened, then it's very important to try and get all of those factual details at the outset to ensure that you can properly deal with the matter and start the investigations that you need to, that Panel's going to touch on now. So whilst those are technical legal steps that you can take, they are useful in getting down to the substance of the matter and dealing with what is required in terms of assessing and deciding whether this is a claim that one would want to ultimately defend or look to settle at an early stage to limit legal costs. Other steps that you can take are in terms of the discovery rules of the High Court and the Magistrates Court, which allow you at an early stage to request documents that are relevant for pleading. So that's in terms of Rule 35.14, or to look at documents that are relevant to the nature and extent of an injury suffered by a plaintiff, and that's Rule 36.4. So those documents allow you right at the start, immediately after receiving a summons or particulars of claim in a slip and trip matter, to request documents that you can use to assess the claim and also to frame and prepare your response in terms of the insured's plea. And that's quite useful because we're going back again to the example, the insured doesn't have any record of what transpired or whether the incident in fact occurred, and that can quite often happen. It's quite useful to get particularly the medical records where, for example, there's a complaint about a fractured femur following a fall. You can request those records in terms of Rule 36.4 to see what the hospital records have to say about whether that is in fact the injury that was suffered, when the injury occurred, and in some instances how it occurred. Often in the emergency room admission documents for third parties or plaintiffs, you'll be able to pick up what was conveyed to the medical staff concerned about how the incident arose. And I had one matter recently where it was the case that no report had happened at the time of the fall to the insured, and they were really in the dark as to whether in fact this incident had happened at all. But we were able to request the third party or the plaintiff's medical records, and from those pick up the fact that this plaintiff had in fact reported that yes, the fall occurred in this specific place on this date and in these circumstances. And it was just useful to have an additional corroborating source in dealing with the claim to get an idea of what we're dealing with. Also, very importantly, in terms of Rule 35.14, you can also request things like a plaintiff's IRP5 forms, tax returns, and so on, pay slips, proof of employment, the employment contracts, and so on. And that allows you to really get a head start in terms of assessing potential loss of earnings claims in order to look at an early commercial settlement. And that's really what you want to be aiming for at the outset, is to get an idea very quickly and as soon as possible of whether this is a claim that one wants to run the entire course and defend, or whether it's one that you can settle at an early stage on a commercial level. And you'll all be aware, obviously, as matters progress in terms of court actions, they become progressively more and more expensive. So being able to do that at an early stage and make a tender in terms of the rules of court, that's a formal tender that places the plaintiff at risk for the costs of the action going forward, really places you in a good position, especially where there are frivolous and inflated claims. It changes the pressure really from the insured side, and particularly the insurer's side, in bearing the costs over to the plaintiff, where you're dealing with a matter that should be settled at an early stage. So having dealt with that from a legal perspective, or largely legal perspective, what to do when one receives one of these claims, in being a high court action that's instituted against an insured, I'm going to hand over to Panel to deal with some of the more practical, factual, and investigative issues that one would look to deal with.
Thanks, Bryce. Good morning, everyone. So the investigation component is a very crucial part in these types of matters. There are various forms of slip and trip matters, as you can see in these pictures. And even though they are cartoon pictures, trust me, these are real life situations. So for example, people slip on wet, slippery tiles, steps, uneven surfaces, signs, items from shelves in an aisle that's falling down, for example, a spice rack, failure to clean up spillages, mats, welcome signs, discarded items, food spillage, also tripping on miscellaneous items like loose cords or a cord from a drill if there's construction going on. So as you can see, the list is basically endless. Going to the actual investigation, you need to investigate as soon as an incident is reported, even if there is no summons and just a letter of demand. We generally recommend that the insurer sends the letter of demand to us in order for us to start the investigation process. Now, why is preservation of evidence so important? Often, evidence won't be available for years. For example, CCTV footage isn't available all the time. It is often deleted after a period of time. And CCTV footage is probably the best form of evidence as it avoids a he said, she said situation. A few years ago, we had a matter in one of the malls where a claimant had an amount of 5 million rand in terms of damages. And we struggled to get the CCTV footage, but thankfully we were able to get it from a neighboring store. And when we reviewed the footage, we saw that her friend and her were walking, they were messing around, and she basically tripped on her own feet. As a result, we were able to get the claim withdrawn. So as you can see, the preservation of evidence is very important, especially when it comes to CCTV footage. If you don't have CCTV footage, it is often difficult to dispute that the fall occurred, as often the third party would have a witness who would corroborate his or her version. So practical guidance on investigations. What do we do when we receive a claim or even a potential claim? Bryce has already covered the necessary notices that should be delivered. Of course, if it is at a letter of demand stage, you can still request these documents. You would just do it in the form of correspondence. Bearing in mind that the correspondence would be without prejudice and clearly stating that the request for documents should not be construed as an admission of liability, you're simply just investigating the claim at this stage. If anyone does require assistance with these generic letters, please let us know. The next step is to set up a consultation with the relevant witnesses. Never leave out the security guard. Almost always they know something. And when you do these witness statements, please ensure that you get contact numbers and identity numbers, because what often happens, witnesses move on, they change jobs or they change locations, and it can be very difficult to trace them. So if you do have the ID number and the contact number, it's a lot easier to then locate them. In summary, these are the things that we look out for when doing these investigations. Foot traffic. You want to know how many people walked over the area in question. This can be determined by looking at the till slips on the day of question, looking at the rough number of people that walked in, looking at the footage, parking tickets, or just really just speak to the store manager to find out a way to determine foot traffic. They generally have a method of doing this. Looking out for disclaimer notices. Retibile will deal with this in a lot more detail, but the one thing you want to look out for is disclaimer notices, indemnity notices, or wet board signs, anything that could limit liability. You should check for every sign in the store to look at the visibility and the probabilities of the customer in question actually seeing the signs. You also want to determine whether you have the relevant disclaimer notice at the time that the incident occurred. If it is a slip and trip matter based on wet towels or substances, generally we get a full breakdown of the cleaning procedure, the method to detect spillages, the cleaning materials in questions, the cleaning rosters, and the cleaning roster for the day in question. You also want to determine whether cleaning is done in-house or whether we outsource the cleaning. Another important point is to look at whether there were any previous incidents at the store. If there were previous incidents, you want to investigate those a bit more to see whether there's any common trends in what is going on in terms of the slip and trip incidents. The one thing we also look at is negligence and contributory negligence. And these are things that you would need to investigate to determine contributory negligence. For example, the type of shoes that the third party was wearing. Was the third party wearing heels or shoes with slippery soles? Whether the third party was wearing glasses, whether the third party consumed alcohol, and also looking at the conduct of the third party after the incident occurred. For example, did the third party refuse medical, which could have contributed to the injuries in question? Also look at how was the third party walking prior to the incident to determine previous injuries. For example, did he or she have a limp when walking? Was the third party carrying any packets, any boxes, anything that could have harmed their vision? For example, we had a matter a few years ago where the plaintiff was holding a box of fruit and veg. As a result, she wasn't keeping a proper look as to where she was walking, and we were able to get an apportionment of 40%. So literally the smallest details in these types of matters really go a long way. Some general observations that you want to look at is the weather in question. Was it rainy? Did it contribute to any slippery substances? Also looking at who is the owner of the premises. Is there a lease agreement? Who has what obligations in terms of cleaning, in terms of maintenance? Looking at the lighting on the premises to determine visibility. Looking at the towels in question. For example, does the insured have non-slip towels in place? You also want to determine whether the third party was a regular customer, known to the security guard, known to the cashiers. You can also look at the registration number of the vehicle to see whether they were frequent at the mall, just to really determine whether the customer was familiar with their surroundings. Importantly, you want to look at the insured's conduct after the incident. Did the insured change anything in the premises? Did they change the towels? Did they install more disclaimer notices? As it can be looked at steps that they could have taken but failed to take. So it's very important to basically get as much information as you can. As the matter goes along, you will find out that witnesses aren't available. Some evidence won't be available, such as the CCTV footage. So it is very important to preserve evidence. And on that note, I will hand over to Jenny.
Thanks, Manal. Good morning, everybody, and thank you for joining us today. For my part of the presentation, I'll be discussing the aspects of negligence and the test for negligence, as well as general defenses raised in the plea. And I'll also be touching on the issue of contributory negligence. So when we look at negligence and the test for negligence, as you may know, negligence is really judged by the reasonable person test. And the case of Kruger versus Kutsia really formulated this classic test for negligence. The test basically inquires whether a reasonable person in the same position as the defendant or the insured would have foreseen the possibility of harm to the plaintiff and would have taken steps to guard against such harm. And the second part of that test is, has the defendant or insured failed to take such steps? If the questions are answered in the affirmative, then the defendant has indeed failed to measure up to the standard of the reasonable person and will be judged to be negligent. So when raising a defense, the defendant or the insured needs to show or state in the plea what reasonable steps were taken to ensure that the harm was in fact prevented. From a general point of view, when looking at defending the claim, the defendant would need to look at whether it has actually discharged its duty to the members of the public, including the plaintiff, by taking reasonable steps to safeguard them against the risk of danger or harm. However, what that duty might be is case specific. Panel sort of mentioned some of the examples, such as having full cleaning procedures or proper protocols to ensure that the floors of the stores are kept dry or cleaned timeously and properly. Another instance might be employing an independent contractor. However, my colleague Lisa will be dealing with independent contractors and the associated liability in more detail. Some of the other general defenses that one might look at would be disclaimer notices and indemnity clauses. If in the particular circumstances of the case, there was a disclaimer notice or an indemnity clause, then the relevant details of that notice or clause would have to be pleaded as a defense to exclude liability. Retibile will be discussing this in more detail, and she'll be also referencing the relevant case law in this regard. Relating to contributory negligence, one of the aspects of negligence that has to be looked at is whether the defendant was actually the sole cause of the injury. So ultimately, if a plaintiff was the factual or legal cause of the harm, then you could have potentially a defense of contributory negligence. The issue of contributory negligence is regulated by the Apportionment of Damages Act. And what this act basically looks at is whether the plaintiff's conduct might have contributed to the harm and is aimed at really reducing the defendant's liability. So when we look at contributory negligence, the defendant really bears the onus of proving that the plaintiff's conduct was in fact negligent. that the same reasonable person test would apply. So essentially, you would apply the Kruger versus Coetzee test, and each party's degree of deviation from what the reasonable person would be looked at and then weighed against each of the party's actions, and a percentage of that negligence would be attributed to each of them. One of the things that might contribute or constitute contributory negligence, which was sort of mentioned by Panel earlier, could be if the plaintiff was failing to keep a proper lookout, if there was affected visibility or poor vision, if the plaintiff was intoxicated or failed to adhere to a warning sign. Again, this would have to be case specific, but these are some of the broader examples that we would look at. Outside of the substantive pleas, there's also special pleas that one could consider. So one of the things would be a special plea of prescription, where you would look at the relevant timelines of when the action was brought versus when the incident occurred. Another one would be a special plea of misjoinder. In this scenario, it's where a party should have been joined, or rather should have not been joined to an action, and has been joined. Another one is a special plea of non-joinder, where a party should have been joined in an action and has not been joined to the action. So if a store owner, for example, should have been joined, that would be one of the examples. If any of the above are applicable to a particular case, then it should be raised in the plea. That concludes my part of the presentation, and I'll now hand you over to my colleague, Rita Bile. Thank you.
I know Rita Bile did drop off. Unfortunately, she lost connectivity. Rita Bile, are you back on? She may be back on as a participant if someone from the I2 team could perhaps just add her.
I don't see her on the call, Bryce.
Okay. There were some hands raised. Perhaps given we have that issue with Rita Bile joining, perhaps we can take some of the questions now. I don't know if that's possible.
Anaki has her hand raised. Anaki, if you could just unmute yourself and ask your question. Okay, it was probably just a mistake, Bryce.
Okay.
Yeah.
We've got a written question from Tato that says, what happens when the plaintiff is unable to corroborate the facts of his or her claim? So I suppose that goes back to the issue of onus, and the principle in the law is that the plaintiff bears the onus of proof in respect of his or her claim. So ultimately, they have the duty to lead or establish the evidence necessary to succeed. Where it becomes tricky is obviously if there are no witnesses and they are effectively the only party that's able to give factual evidence, it becomes hard to challenge it. And you can perhaps look at circumstances around being able to try and pick holes in his or her case, but it does make it quite difficult to deal with. And that's where the issues such as the CCTV footage that Pernell mentioned becomes particularly important, in addition to being able to try and get hold of other documents that may be used to either refute or confirm what the plaintiff's saying, like I discussed around documents. And really those medical records, if you're complaining of a fractured femur, you must have some kind of medical records that are going to tell us that, you know, when the injury was sustained, roughly what the circumstances were. That should all be reflected in the medical record. So that is one way of trying to deal with a matter where the plaintiff is the only real witness to what occurred, is to try and get hold of other extraneous evidence that you can use to either confirm or deny what's being alleged by the plaintiff. I hope that answers the question. And are there any further questions at this stage, or do we have Rita Bile back on?
Just trying to find Rita Bile. I think I did see another question come through. Just give me 1 second. So Carmody is asking, what's the position around releasing CCTV footage? Is an insured obliged to release the footage if a third party requests it prior to litigation?
So I think it depends. I think you would be entitled to deal with it in terms of the PIA Act. So you could require them to make a formal request in terms of the Promotion of Access to Information Act. And certainly the bigger retailers or property owners might well have those or should have those PIA policies in place. There's always the specter of poppy lurking in the background, but one would expect that where they have you were involved as a third party in an incident, and you require that information to pursue your rights, as the case may be, in respect of a claim, then that sort of information you would be entitled to, or documentation or video evidence you would be entitled to. It obviously depends on the circumstances and the scope of the request. I mean, if they're asking for CCTV footage for 2 years prior to the incident, then it's obviously excessive and probably outside the scope of what they would require in order to actually deal with the merits of their claim. But certainly we would in most instances say, listen, where there's a third party that's made such a request, as long as the request is dealt with in terms of the applicable PIA policy or whatever the case may be, then you'd have to provide that information or that video evidence. Where it comes to court processes, those things would be discoverable. So there would be requirements in terms of the rules to disclose that those video and tape recordings. That's in terms of the discovery rules. And if you didn't do it initially when one should have, then it's likely that you'd be met with a Rule 35(3) request for further and better discovery, where they would specify and say that they want the CCTV footage. But once actions commenced, they have to wait for discovery to happen. So that's the other thing, is if they issue a summons and particulars of claim, they then have to wait for the pleadings period to close before they can make a request for discovery. So it would be irregular to request it before the close of pleadings, when discovery processes kick in. And that might allow you to delay it somewhat if for tactical reasons you wanted to. Are there any other questions, or can we look at moving on? It looks like Retabile is on, but perhaps via a mobile device.
Correct, Bryce, she is on.
Okay. Retabile, are you there, or should we move on to the next panelist? Okay, I'm going to move on to Lisa's component, and then hopefully Retabile's issue will be resolved. I do apologize from our side. Hopefully it will be rectified, but in the meantime, let's move on to Lisa and the cases that she was going to deal with.
Hi, good morning, everyone. I'm going to chat to you about some cases dealing with vicarious liability and the liability of independent contractors in slip and trip claims. So the general rule in our law is that although an employer may be held vicariously liable for the wrongdoing of an employee is not responsible for the negligence or wrongdoing of an independent contractor. In the Charter Props case, the plaintiff sued a mall owner and its cleaning company for damages when she slipped and fell in a mall. She alleged that the cleaning company was negligent in failing to detect and remove a spillage, and that the mall owner was vicariously liable for the cleaning company's negligence. The High Court had found in favor of the plaintiff, and the owner and the cleaning company appealed to the SCA. The SCA explained that the correct approach to the liability of an employer for the negligence of an independent contractor is to apply the fundamental rule that obliges everyone to exercise the degree of care that the circumstances demand. So an employer is not obliged to take any further steps than are reasonable to guard against foreseeable harm to the public. The SCA found that by engaging an independent contractor, the mall owner had taken the necessary care incumbent on it, and there would have been no way for the mall owner to have known that the contractor's work would be defective and result in harm to the public. So the SCA found that the harm was caused solely by the wrongdoing of the contractor and absolved the owner of liability. In the Holtzhausen case, the plaintiff sued the owner and manager of the mall for injuries she suffered when she slipped and fell at the mall. The tiles at the mall were wet and slippery as a result of rain carried in by rain jackets and umbrellas and the shoes of people that were coming in and out of the mall. And expert evidence revealed that the tiles were dangerous when they were wet, so they were slippery when they were wet. The owner and the manager denied negligence on the basis that they had appointed a competent contractor to maintain, clean, and check the floors and ensure that they remained free from spillages. And the cleaning contractor was not required to constantly dry floors when they became wet, and they were only required to keep them clean and free from spillages. The High Court had found that the defendants were not liable because the mall owner had discharged his duty to keep the mall floors safe by engaging a management company, and the management company had similarly discharged its duty by engaging the cleaning company. But on appeal, the full bench of the High Court distinguished this case from the Charter Props case on the basis that the rainwater brought into the mall by the shoppers was not a spillage, as a spillage involves something that is accidentally spilt on the floor. And the High Court reasoned that spillages must be distinguished from instances where floors are inherently unsafe or dangerous because of their composition, in which case the principles laid down in Charter Props would not apply. So the full bench found that liability could only lie with the owner and the manager of the mall, as they bore a legal duty to take reasonable steps to ensure that the mall floors remained safe. And this could have been done quite easily by contracting the cleaning company to dry sections of the floor that became wet when it rained, or just to close off entrances that were exposed to the rain. Since neither of these steps were taken, the defendants were found to be negligent and were liable to the plaintiff for her damages. So the next case is the Pete v. Boxer case. This does not actually involve an independent contractor, but it highlights the duties placed on a shop owner where their employees' conduct contributed to someone's loss. In this case, the plaintiff slipped and fell at the defendant's shop due to cake flour that had been spilled on the floor by one of the shop's employees. The plaintiff alleged the shop had a legal duty to ensure that the store was safe and free from any danger that could pose a risk to the public. The defendant pleaded contributory negligence on the basis that the plaintiff should have kept a proper lookout and that she failed to take reasonable steps to prevent her fall. The defendant's sole witness gave evidence that she saw one of the defendant's employees packing flour when the plaintiff fell and conceded that the flour on the floor likely caused the plaintiff to slip and fall. She also noted that the flour that the plaintiff had slipped on had in all probability come from the bags of flour that the employee was packing. So regarding the defendant's contention that the plaintiff's own negligence had contributed to her loss, the court referred to the case of Props versus Pick and Pay and said that when shopping, shoppers tend to focus their attention on the shelves and the goods on the shelves and not on the floor. And the flour, which was a white substance against white tiles, was not visible to the plaintiff, and the defendant's employees should have ensured that its floors were kept clean or warned shoppers of the hazard. Ultimately, the court found that the shop did have a legal duty to keep the floor clean and free of hazards to shoppers, and as the defendant had failed to do so, and because it was not onerous, just for the shop's employees to clean the flour off the floor or warn the shoppers of the risk, the shop had breached its duty. And in the circumstances of the case, there was no contributory negligence on the part of the claimant, and the defendant was found to be solely liable for the claimant's damages. We are often asked how often cleaning staff are expected to sweep through an area and mop up spillages. And I'm just going to take you through a couple of cases on this issues, which you will hear don't really set out a clear time frame. The Lindsay versus Checkers case tells us that each case is to be considered on its own facts. So, for example, if there's condensation that is consistently dripping from a freezer, this area would need to be swept and cleaned far more frequently than something like the canned goods aisle. In the Charter Props case, a sweep every 5 minutes was found to be appropriate, but this wasn't actually adhered to by the cleaning staff. The Props v. Pick and Pay case tells us that a spillage is to be cleaned with reasonable promptitude and also considered on its own facts. So where the spillage occurred and what kind of foot traffic moves through the area will be decisive of how often that area should be checked and cleaned. Okay, thank you, everyone. I think I'm going to hand over to Retabile if she's on, or to Annika if Retabile is not on.
Thanks, Lisa. It looks like, unfortunately, we still don't have Retabile on. Retabile, just checking.
Not on, not on.
Okay. All right. Well, I'll do the best I can, not having prepared on this section. But I think a lot of these cases, many of you probably would have come across or had seminars or talks on them previously. So I'll touch on them briefly. But really, they concern the issue of disclaimer notices and indemnity clauses. And it's something that I think all of you would have dealt with in the scope of the work that you do. And it comes up frequently in terms of to what extent can one rely on disclaimer notices or indemnity clauses in contracts to exclude liability, especially in the retail and the property space where one has buildings that members of the public frequent or stores that customers are in and out of all the time. So it's something that we deal with quite often, and certainly the question around whether or not one can actually rely on them is something that we get asked frequently. So the classical case dealing with disclaimers or waivers of liability is the Water Wonderland matter, which I'm sure many of you would have come across or heard of before. And there, Miss Botha and her minor child were using a ride, or had paid to go on a ride down on the Durban beachfront. And in the course of making use of the ride, there was a seat fastener that malfunctioned, and they fell out and injured themselves. And the primary defense relied upon by the defendant, being the Water Wonderland, was that on the ticket stub that was sold to the plaintiff, and also on behalf of her minor child, there was a disclaimer of liability. In addition to that, at the ticket office itself, on the one side, there was a notice indicating that the owners and so on would not accept liability for incidences of injury and so on in using and being on the ride. And you'll probably be aware that ultimately the court was persuaded to accept the fact that because the risk and also the disclaimer was brought to the attention of Ms. Botha and her minor child, in those circumstances, there was a binding contract which had been accepted by Ms. Botha as the plaintiff, and that effectively served to disclaim or eliminate liability on the part of the owners and operators of the Water Wonderland Park in Durban. And I'll get into it now in the next two cases, but again, the facts of a matter play a massive role in determining whether or not one can rely on a disclaimer notice. In addition to that, it must be borne in mind that Water Wonderland was decided prior to the advent of the Constitution, and certainly the advent of the Consumer Protection Act. And one has to tread very carefully when you're dealing with disclaimers to ensure that the wording doesn't fall foul both of public policy under the Constitution and of the requirements for unlawful contract terms under the Consumer Protection Act. And one that immediately jumps to mind is excluding gross negligence under the Consumer Protection Act, or liability for injury arising as a result of gross negligence on the part of employees or agents, as the case may be. So that is always something that needs to be borne in mind. And an important one in terms of how, a case that's important in terms of how these notices are brought to the attention of members of the public, is the Stearns versus Robespec case. And there, a member of the public went to a large retailer, and while there, injured his bicep on I think it was a section of shelf that was protruding out from one of the aisles in the shop concerned. And the shop or the owner of the retailer relied on a disclaimer notice that was posted at one of the entrances to the store in question. And ultimately, the court wasn't persuaded that the store could legitimately rely upon the disclaimer where it was not suitably brought to the attention of members of the public, and particularly Mr. Stearns in entering the center. As I recall, it was set out and you probably would have seen them going into many supermarkets yourselves. It was put in small font in amongst a whole lot of things about no rollerblading, no loud noises, no weapons, and so on. And it wasn't suitably highlighted for the purposes of the customer in question being aware of the fact that he was assuming a disclaimer or accepting the disclaimer by entering the premises. So again, it comes back to Pranal's question of where are disclaimers situated? Are they suitably visible? And is the wording obvious enough that customers can't possibly miss it in entering a store, and thereby a contract comes into existence? The final case is Cooper versus Shamwari Game Reserve, and that concerned a disclaimer or waiver of liability in not an admission, but a document signed by the plaintiff when she arrived as a guest at a safari accommodation in the Eastern Cape. And what happened there was she was making her way back to a restaurant or a room after having had apparently two or so glasses of wine, and she fell into the pool and injured herself quite badly. And what was raised was the disclaimer that was contained in the admission contract at the time that she arrived. And you probably, if staying at many resorts or places where accommodations offered, would have signed a similar sort of agreement. And the safari accommodation relied on that as a defense to the claim. And she firstly raised the issue of whether or not the disclaimer suitably complied with the terms of the Consumer Protection Act, and also the fact that it hadn't been properly brought to her attention in signing the agreement. And the court sort of skirted around the issue of the application of the Consumer Protection Act to a large extent, but did comment in dealing with whether or not it had been suitably brought to her attention that you had a situation where these sorts of contracts are routinely signed in these sorts of contexts where accommodation is offered, and it was not unusual for such a term to be included in it. But ultimately, the court was satisfied that the incident arose as a result of Ms. Cooper's negligence, because she had been aware of the fact that the pool was situated where it was, and apparently had walked past it on a couple of occasions in the course of her stay. I think it was her first day, but she had been back and forward past it, and she had apparently not been paying attention and had gone the wrong side of a large potted plant that was situated on the edge of the pool and had fallen in. And if she had been exercising proper care and proceeded with the necessary caution, the incident wouldn't have arose. So those are some cases where the issue of disclaimer notices and waivers in terms of contractual terms have been dealt with. And I'm sure there'll be some questions at the end, but I'm going to hand over to Annika to talk about how to deal with settlements and resolutions in slip and trip claims.
Thanks so much, Bryce. Hi again, everyone. It's really nice to have you with us this morning. So I'm just going to start with nuisance offers and nuisance value settlements. So the term nuisance value actually stems from the idea that it is better to pay a little bit of money than to have to deal with the nuisance of a claim that just won't go away, because the cost of fighting the claim outweighs the amount claimed. Now, insurance companies occasionally decide to make a nuisance offer, usually in agreement with their legal representatives. The small settlement is meant to placate the insured and discourage them from pursuing a claim that will cost the insurer more money than the claim itself. So why settle then? So settling disputes can be a more desirable and cost-effective way of resolving a dispute, as well as provide parties with certainty and closure. When parties have reached an agreement to settle, the parties are free to record their settlement in any manner, but from an evidential point of view, a settlement agreement should be reduced to writing and signed by the parties to the agreement. Because a settlement agreement is a contract, it must comply with all the general contractual requirements, being consensus, certainty, legality, and possibility of performance. Now, courts encourage settlement negotiations between parties. In fact, Rule 37 of the Uniform Rules of Court require parties to request of their opponents to make a settlement proposal and to react to such a proposal. Settlements are, however, not always reached at pre-trial stage of the proceedings, and this requirement is often just treated as a formality by the parties in order to obtain a trial date. Settlement can take place at any stage during the litigation proceedings, but obviously the sooner it takes place, the more costs are saved. There is no requirement for a court to approve settlement terms in most proceedings. However, if the plaintiff's attorney was acting on a contingency fee basis, the Contingency Fee Act requires the settlement agreement to be approved by the court. In other proceedings, however, there is no need to file a copy of the settlement agreement with a court. This is merely an obligation by Rule 41.3 of the Uniform Rules of Court on a plaintiff in court proceedings to inform the registrar should settlement be reached. There are, however, no statutory obligations mandating parties to participate in settlement negotiations, and there are no real consequences for a party who refuses to participate in settlement negotiations. Where one of the parties requires settlement agreement to be made in order of court, the fact that settlement was reached will become a matter of public record, as will the terms of the agreement, and the court cannot order the settlement terms to be kept confidential at the request of the parties. And if a settlement agreement is made in order of court, the sheriff may be instructed on the strength of a writ of execution issued by the court to enforce the order in the event of default. Now, this brings us to the question of confidentiality. Settlement agreements are not automatically confidential, but good faith negotiations to settle are legally privileged and inadmissible in court. In order to ensure the confidentiality of a settlement agreement, it is advisable to include express wording in the settlement agreement to this effect. However, such confidentiality would not preclude a party from taking legal steps to enforce the terms of the agreement. Now, the purpose of without prejudice communications is to ensure that parties are able to enter into settlement negotiations and discussions without fear that their statements will be used against them. Admissions made during the course of genuine negotiations to settle a dispute will be regarded as being done on a without prejudice basis, even if the correspondence is not marked without prejudice. It is, however, best practice to mark these communications as without prejudice. So this now brings us to breach. In the absence of express wording to the contrary, contracting parties have the right to elect whether to enforce specific performance of the settlement agreement or to cancel the agreement and seek damages in the event of breach in accordance with the normal principles of the law of contracts. Parties are free to indemnify each other for all costs, expenses, or damages arising out of a breach and any required subsequent enforcement of the terms of the agreement. Now, you can also sign a release and discharge form, and a release is an agreement to renounce some or all rights against a person. Release and discharge forms may be included as part of a settlement agreement and is a document signed by the claimant, wherein the claimant releases and forever discharges the defendants and the insurers, past and present, of any liability arising out of or in any way connected with the facts that gave rise to the matter. There may be a confidentiality clause in these agreements where the claimant acknowledges the terms and conditions of the settlement agreement and that they are confidential, and that these details may only be released with the consent of the defendant, and the claimant then agrees to withdraw without any reservation, any allegations or liability which it has made against the defendant in connection with the above mentioned matter. Usually when we make recommendations to clients on a settlement amount, we will seek instructions to negotiate for an amount lower than the reserve amount to allow some room for negotiation. And the reserve amount will be an estimate of what the claim is likely to cost, and then we will recommend that that amount of money be set aside by the client. Thank you.
Thanks, Annika. With that, we can hand over to some questions. I see there have been some that have come through in the chat function, and I don't know if we're able to also take some verbal questions. There's a couple of hands raised.
Bryce, there are quite a few questions. I'll go through them in order, hopefully in the order that they arrived. So Bongani is asking, from your experience, does a disclaimer notice by the insured party actually stand as a defense mechanism in court at claim stage, especially on property type risks, for example, parks, dams, and swimming pools?
So there's no reason why they shouldn't, and they have been upheld by the courts, recently, and not just in the cases that we've referred to. It is just a question of being careful about the wording and a fact-specific question around how obvious was the notice to patrons that are coming in and out, or members of the public that are coming in and out of the property. Where it's not situated in an area that's very obvious and is clearly drawn to the attention of members of the public, I think it becomes more and more challenging, as in that Probst case, to rely on it. And I would be hesitant about relying on it in those circumstances as a sole defense. But having said that, I mean, I dealt with a matter some time ago where the third party concerned was someone who was frequently at the shopping center in question, and worked on a contract basis with a couple of the stores at the center, and she tripped and injured herself on an uneven surface at the center. But there were numerous disclaimer notices displayed in bold on routes that she would have probably walked 4 or 5 times a week. And I think in those circumstances, you would have a strong case to rely on the disclaimer notice where the wording is appropriate. It's easily brought to the attention of members of the public. And also if you can show that the person concerned could not possibly or could not reasonably have missed the notice in frequenting the store in question, then those all stack in your favor. But a once-off customer that's down in Durban from Joburg, has never been to the center before, and the disclaimer notice is tucked away behind the lotto stand at the store, you're going to have a challenge, I think, relying on the disclaimer in that context. So I think the short answer is it's very fact specific, but there isn't a reason why, if it's properly displayed and the wording's appropriate, you shouldn't rely on it.
Cool, thank you. There were 2 other questions that were relating to disclaimers, but I think you've covered them. But I'll read them out just in case there's something else. Is a disclaimer really enough? And are typical disclaimer notices of real value in avoiding liability?
Yeah, I think that hopefully the answer that I gave there covered it. But there's some very good, I've come across some very good standard forms out there and some very bad standard forms. And look, generally in my experience, the property owners, especially malls and so on, their wording tends to be quite good, and unfortunately retailers' wordings can be problematic. That's just my personal experience in matters that I've dealt with. Some of the retailers' wordings are not great, whereas property owners and so on tend to have fairly decent wordings.
Cool, thank you for that. And then Anton asks, if you believe that a claimant was under the influence, I'm assuming of alcohol or some sort of drug, how does a client obtain sufficient evidence to show that they were under the influence of alcohol?
Bernal, you've dealt with a couple of drunk plaintiffs before.
Yeah, I have. I'll take that one. Thanks, Bryce. So sometimes it is a bit difficult. You can't go there and make the allegations he alleges must prove. So I've had 2 matters in 2 ways that we've dealt with it. The easiest way is medical records. So I always say you struck it lucky if the claimant got injured and went straight to hospital. And sometimes if they do the various blood tests and stuff and you review the medical records, you can see the different levels and find out if they were intoxicated. That is your best form of evidence. But unfortunately, in some instances, you don't have medical records to confirm it. I've had another matter where it was the witnesses who said that when they went up to pick up the claimant, they could really smell the alcohol on him. And he made a passing remark, "I drank too many beers this morning," or something of that sort. So that ended up being really good evidence, and it's something that you want to record in the witness statement as soon as possible. So if the matter goes to trial 4 or 5 years from now, you can basically show up with this witness statement or have the witness in the box who would be able to lead this evidence for you. Because often what happens is in the moment they make these allegations or they make these comments, but when it comes to trial, they basically deny it. So you would need something to corroborate that version, but medical records is mostly the best. Sometimes you can rely on CCTV footage if you can see them wobbling a bit, but again, that's up to speculation. So you would need something to just substantiate it. But medical records are always the best. So often what we would do is when we do the notices that Bias spoke about, like the 36-4 notice, we would specify medical records for the day in question, or just to look at those records in particular.
Just one more comment on that issue is, you know, in dealing with things from a legal perspective, if you plead a bare denial, then it's for the plaintiff to prove their case. Whereas if you raise a substantive defense like the plaintiff was drunk, then that swings the burden onto your side in respect of that specific issue. So you would need to have, as Penal said, have cogent evidence to support that allegation in order to succeed. Yeah, just something to bear in mind.
We seem to have quite a lot of questions on the disclaimer notices, so I'll do the last two, and then Charmaine, I'll come to your question. So Johan says that disclaimers that include words such as "howsoever arising" appear to attempt to avoid liability, even where there's gross negligence. He says this surely goes against the spirit of the law, so why are they even allowed? And then Melita says, is it right to avoid your negligence where you have clearly been liable by just putting a disclaimer notice?
So I think the first one there was around disclaiming gross negligence, as I understood it.
Correct.
And that would be contrary to the Consumer Protection Act. You can't have a term that excludes gross negligence or intentional acts on the part of employees or staff or the defendant. So in that context, you'd fall foul of the Consumer Protection Act. There may be some context too where disclaiming negligence could arguably be contrary to public policy. I know I have seen it in the healthcare space where that's been raised. I haven't litigated it, but there have been instances in historical cases like the Afrox case where the disclaiming of liability on that basis was successful. But plaintiffs nowadays would generally respond to a suggestion in most instances that you disclaim negligence to say that you did so on a basis that was contrary to public policy. And if I recall correctly, that was also dealt with in Cooper as an alternative, that Cooper versus Shamwari, where it was not only a Consumer Protection Act, but that the terms of the disclaimer that the Safari accommodation attempted to rely on were contrary to public policy. So that's a long winding answer to say that no, you can't disclaim liability for gross negligence. Is anyone else in the panel that wants to add anything to that?
I just think the wording is also so important. I saw somebody mention it in the chat function. If you just, it's very broad and says whatever negligence, however arising. I mean, that's a bit ambiguous. And the CPA is quite clear on what it is that you need to do for a disclaimer notice. They also look at various things like the font of the disclaimer notice. So if you're standing 2 meters away, are you able to see it? And bearing in mind that everyone views things differently in terms of heights. So you really got to go all out to ensure that it's visible to a reasonable customer walking in. And I think the CPA gives you a lot of guidance as to what it is that you need to put in and leave out, actually.
Thank you, Pranal. So Charmaine is asking about the retail stores that provide hand sanitizers at the entrances. So obviously this causes some spill or liquid dropping on the floor at the entrance, particularly the no touch. So what is the expectation of a retail store? Is it expected and reasonable of a retail store to have somebody at the entrance to mop up the floor? just bearing in mind the footfall at the store entrance is where the hand sanitizer is situated.
Yeah, I mean, that's quite an interesting question. I must say, I'm quite surprised we haven't seen any of those cases yet in light of this pandemic. But it goes back to the cleaning procedure, because similar to if you had a perfume drop in a mall or in a store rather, you would have to have a procedure in place to detect spillages. So I would imagine that if you have cleaners working on rotations, there is a policy in place that if they're not sweeping from 8 to 10, they've got to walk around and detect spillages. That's part of the cleaning procedure. So it would really look at what is their obligations in terms of detecting spillages. And even though it is at the entrance, it still forms part of the store. And the easiest way I would think to deal with it is that if you've got a security guard there, it's not their obligation, but there's nothing stopping them from informing the cleaners that there's a spillage, they need to clean it up. So we haven't seen a matter of that magnitude yet in terms of sanitizers, but I would imagine, and I would probably say that it applies the same sort of thing as any spillages inside, whether it's from a perfume bottle or anything of that sort, you would still have some obligation to detect the spillage. Knowing that sanitizers can actually spill, it's something that's foreseeable and you would need to guard against that harm from occurring.
Lisa, I see you unmuted yourself. I don't know if you had something to add there.
Yeah, I just want to add that because everyone sort of knows that there are going to be these hand sanitizers at the entrance of a shop, there might also be a duty on a shopper to sort of be a little bit more careful at the entrance, because you know there's probably going to be some hand sanitizer on the floor. And then also for a shop, if you have one of those that just spills all the time, then what might be reasonable there is to get a different one. So yeah, it would be interesting to see how it goes.
Also, I mean, your Holzhausen case that you spoke about, Lisa, the bottom line is, in terms of time and detecting and deploying cleaning staff, the expectation is that you don't have persistent risks, expose the members of the public to persistent risks. So in Holzhausen, if I remember correctly, the issue, one of the main issues there was that this rainwater, or the rain, the dampness that was emanating from the entrance and coming onto the tiles at the entrance to the center, was assumed to be a persistent risk that should have actually been remedied, rather than having someone coming through every 5 minutes to sweep it off. So where that's the case, and I think first prizes, like you say, Lisa, if it's something that is posing a consistent risk and there's a better solution in terms of another device that does the same thing, then get that. But if for whatever reason you can't, you need to be careful about the fact that this is something that's a persistent risk, and deploy additional staff there to deal with it as the case may be. It looks like there's still quite a few questions coming through, so
Yeah.
happy to carry on making them.
I just wanted to, before you carry on, Bryce, just to say thank you to everybody that's on the call. If anybody needs to drop off, you can more than welcome drop off, but thank you for attending. And if you guys still have time, we can continue taking the rest of the questions.
Yeah, that's fine. We're happy to carry on. Hopefully we can address as many as possible.
Awesome. Now we know when you guys come on, we should allocate 90 minutes.
Well, I'm sorry, we won't keep everyone for too much longer, but
No,
we can
all good, all good.
Yeah.
So Babuloki asked you to please explain forced liability.
Forced liability.
Would that be like force majeure?
I'm just going to ask Babuloki to unmute himself. And
Okay.
Babuloki, are you still on the call?
Yes.
Hi, hello. Yeah.
Hi, how are
Hi.
you?
Yeah, I'm good. Yeah, I'm here joining in from Botswana. So our attorneys have mentioned that there's something that's been adopted. Is it in South Africa that's going to be coming our way here that is called forced liability? I don't know if I'm spelling it right. Yeah, but it is that forced liability. So yeah, that's why I wanted you to touch on that and maybe try and explain a bit on that.
Just in terms of the concept, it might be something like strict liability out here.
Yeah, something like that. Yes.
Yeah, so that was looked at in the charter props case, around where you own and tell me if I'm not getting this right, because I must admit I haven't come across that concept myself in South Africa. But if it's similar to what we would consider to be strict liability, it's where, for example, you create a dangerous situation, you then are required to are held to a higher threshold in terms of avoiding harm to others as a result of that situation. So, it was argued in charter props that where you own and operate a store or a shopping mall or whatever the case may be, and you have members of the public coming in and benefiting you commercially in terms of making use of your facilities or purchasing goods from your store and so on, you are expected to kind of go over and above even the normal reasonable man standard in terms of avoiding the chance of harm arising or occurring to those people. Am I sounding like I'm on the right track?
Yes, most definitely. I think I got the term wrong. It is strict liability. So what I was, the reason why I brought it up is because, I mean, it to me, when one of our attorneys here, Paula Botswana, explained it, it came across as, you don't have the claimant doesn't have to prove negligence on your part. As long as somebody else is injured in your premises, then it's strict liability. You have to settle the claim. You don't have to prove negligence.
Yeah, so that's pretty much what I'm describing. Although strict liability, you could assume it by contract, but then there are concerns in terms of your insurance cover, because in many instances there are exclusions where you've assumed liability under policies. So that's something to just bear in mind, is if the insured has by contract assumed strict liability for something, then that might be a cause for concern under the policy and whether the policy would then respond. So that's the first comment. And then the second comment from the South African perspective is the charter props case stands as authority for the fact that you don't have a higher threshold for property owners or retailers where you've got members of the public. All that's required is still that you just meet the standard of a reasonable person in avoiding or taking steps to avoid harm to customers present on your premises, which is what I think it was it Lisa that dealt with that, the charter props case. Yeah, so it's the normal standard. It's not correct to say that you have a higher threshold as a retailer that you have to meet. It's the same test as in the Kruger versus Coetzee that Jenny spoke about too, being the reasonable person test. So unless you, and I can't see a context that you would, but unless you as a retailer or property owner assumed strict liability through contract, you wouldn't be held to a higher standard than the normal reasonable person test. I hope that answers the question.
That answers it, man. Thanks a lot. Thanks a lot. The main takeaway again there is that even if the property owner is held liable, it doesn't necessarily mean that when you're handling a claim like that, the insurance company should be called to pay because certain policy terms and conditions wouldn't have been met. You understand? So I think that's the main takeaway. But thanks a lot.
But just be careful about your Botswana specific advice. But I hope that we've explained the position out here.
Yeah, no, you have. Thanks.
Yeah, sure.
Right. Sure.
Sorry, can't find my unmute button. Team, so Veli is saying that brokers should remember important aspects of the insured. Sorry, I read that incorrectly. So some of the aspects that the brokers should keep in mind are things like processes that need to be in place, record keeping, cleaning rosters, witness statements. Is there anything else that you would tell our brokers to just be mindful of and advise their clients of in terms of record keeping?
Definitely CCTV footage. and make sure that there's copies saved on USBs, because what we find is sometimes they extract the footage, it's saved on one USB, the USB goes missing, nobody can then find it. And just making sure that the original is kept in a safe place as well, if there's any dispute about tampering with the footage.
And I think also just another good to do is to make sure that staff are alert for incidents. So, you know, it might even be, often we have cases where the third party has initially said, listen, I'm fine, it was silly me type thing, and I'm actually fine or whatever. And then it comes back a month later and it's a huge issue. They've picked up a fractured coccyx and you know, and now they're quite keen to take legal action. So I think training staff to, as soon as an incident like that occurs, whether or not there's a suggestion that there's going to be a claim or not, as soon as there's an incident, to document it, you know, make a note of any witnesses, just to protect the insured in terms of any ultimate action that may materialize. Because, yeah, often everyone seems fine and everyone agrees that it was nobody's fault, and then someone talks to the family lawyer and you have a court case coming your way. So it's a good idea to train employees to be alert and to record and document those incidents.
Yeah.
I also think it's important to take as many pictures as possible, because what you sometimes have is that they've got 3 years to institute these proceedings. So by the time you get the summons, there may have been renovations in the store, so you can't really see what the store looked at when the incident occurred. So it's very important to take those pictures and just keep it in file.
There was a written question about how long the third party has to claim, or a plaintiff has to claim, and Pernell's just answered that. Obviously 3 years from, in this context, really the date of the incident, because the damage or the injury would have arisen at the same time. So the third party would have to bring a court claim, a court action within 3 years of the date of the incident. Otherwise it would be considered to prescribe or have prescribed, and then in that case they barred from proceeding further. Obviously, in terms of claims notification, there are other time periods involved, but that's really an onus on the insured in terms of notifying an event. But that's a different question.
Cool. I think we'll take 2 more questions and then we'll wrap up. So Heidi is asking about, can a shopping mall be held responsible for human trafficking, particularly if there's video footage of events? So there was a video, there's a video that's been going on social media about this one lady who believes she's being followed and somebody's trying to traffic her. So how would that be dealt with?
Yeah, I can't say I've ever dealt with the matter. And I mean, Bryce, you'll shed some light on whether you've dealt with it before. But would you imagine what obligations a mall owner would have? You would have to reasonably keep your customers safe because you're inviting them in as patrons. But I think it would be excessive if a court had to find a mall owner liable for human trafficking. As long as they've got relevant measures in place, they've got security. At the very least, they would have discharged that onus in terms of keeping their customers safe. But I do think it would be pushing the boundaries quite a bit to make them liable for human trafficking.
I think that would be I think it would be a difficult claim to make. And it comes down to, whether that sort of thing you should be required from a legal causation perspective, whether you should be expected to be held responsible for that sort of a quite remote risk, I would imagine. But having said that, if you offer a play center for parents to drop off their children for, child minding while the parents are off shopping, and a child is abducted in that context, then I think you would be on the hook, because you've assumed that risk or assume responsibility for the care of that child in the context where it's clear you'd be expected to take reasonable steps to guard against exactly that sort of thing happening. Whereas the intentional criminal conduct of someone else on an adult that's present at your store, assault is another one. I think I actually have dealt with one case where there was a question around a customer being assaulted at a store, and what duty the the store had to mitigate or avoid that kind of a risk or that potential harm from arising. And I think the advice ultimately we gave there was this: it was too remote. You're dealing with intentional conduct on the part of another party that's not your employee or whatever, and in that context, liability wouldn't attach. But yeah, I actually have seen that video too, and it's quite horrific, the things that do seem to be going on. But I think it really depends on the extent to which you've assumed responsibility for that kind of a risk in your premises. Yeah.
Yeah, and I think if you are sued, you might want to look at doing a third party for your security company if there is any link to it. We often do see there's issues with security, maybe not of that magnitude, but for example, where the security was, checking this woman's bag, and then she claimed because it was an infringement of her dignity and a whole host of things. So we were acting for the shop owner, but we actually joined the security company. So in those instances, you always want to look at what is your SLA or your contract with the security company, if there's any way to join them to the proceedings.
Thank you. Thanks for that. Last question. It's not the last question on the chats, but I think in the interest of time, we'll just take this as the last one. Karen is asking, does a disclaimer, which forms part of an accommodation registration form in a game reserve, for instance, in respect of damage caused by wild animals, sufficient? Or would the reserve be required to make sure that the dedicated parking area would they be required to make sure that the dedicated parking area is safe, or should they be displaying disclaimers in that particular area?
So again, I mean, I would think it depends on the circumstances, but if you know that there's wildlife around, it probably is better to put up further disclaimer indemnity notices and just those general big warning signs, because the ones that you sign when you do register as a guest is very broad. It just says any injury, any damages, and those sort of things. It doesn't actually specify that there's wildlife that could actually injure you. So I would say, to err on the side of caution, you would definitely need those bigger indemnity signs that says warning, be cautious, enter at your own risk if they are going past the fencing or something of that sort. So yeah, something more than the general guest registration. Not sure if anyone on the panel had any similar dealings.
Yeah, I would think that you do have, I mean, it depends on the facts again, as I think in most of these sorts of situations. But if you're in a big 5 game reserve where the lions and rhinos and elephant and leopard are all roaming free in amongst the camp, I think you can't just have a disclaimer that says, cool, you agree that you don't hold us liability if something like that happens and you are injured or attacked by a wild animal. I think you have to have it some additional steps. I mean, if it's an unfenced safari lodge, or as the case may be, you should be saying, listen, don't leave your rooms at night. And if you do need to leave the rooms at night, you need to request a ranger to escort you, or make arrangements for rangers to escort people to and from rooms and that type of thing. So I don't think it probably wouldn't be enough to say, we disclaim liability and then let the guests roam free. I think you would be expected to at least take some other steps to mitigate that risk. And that might not be fencing off the entire place. Although if you're trying to avoid liability, that might be the best approach. But if people are coming to your reserve specifically because they are seeking that kind of a level of interaction, and you've disclaimed liability and you've taken reasonable steps as far as possible, and I would think off the top of my head that does involve saying you may not leave your room at night, and if you are coming to and from the lodge and rooms, you're escorted by a ranger, then I think you're probably covered. But again, very fact specific, and it would depend, but that's sort of just a general comment.
Kamini, I don't know if you want to come back on. I don't see Kamini on the call, but just on behalf of iTOO, Norton Rose team, thank you so much. I think this has been like one of the most informative sessions we've had in a long time. So thank you very, very much for your time. Thank you for imparting knowledge with us. There's lots of thank yous and appreciation on the chat. I think we'll definitely call you back for another one of these great sessions. You've just made everything's just so easy to understand, and thank you so much.
Thank you. It was great to be on. And yeah, if there are any pressing questions that anyone wants to get in touch with, I think our details are all of our details are online and may well already be available through iTOO. So we're happy to chat, and thank you to iTOO for having us on. We really appreciate it. It was good to share the morning with you.
Awesome. Thank you, guys. Thank you, everybody, and have a great
right.
Tuesday further.
Cheers,
Thanks,
everybody.
everyone.
Thank you, everyone.
Thank you, Bryce. Bye-bye.